Welcome to the debate. In a matter of weeks, millions of Nigerian voters might find their preferred presidential candidates entirely erased from the 2027 ballot.
Right, and not because those candidates lost an election, or even because they ran out of campaign funds.
Exactly. It's because of a single judge's interpretation of essentially an internal party legal maneuver.
Yeah, and when that judicial order practically blocks major figures from fielding their mega coalition, we're talking about Atiku Abubakar, Peter Obi, Rabiu Kwankwaso, and Rotimi Amachi. We are no longer just talking about legal procedure. We're talking about the potential decapitation of the country's primary opposition movement.
Which is exactly why we're examining the recent, really monumental ruling by Justice Joyce Abdulmalik of the Federal High Court in Abuja.
Suit number FHC ABJ CS 581 2026 for those tracking the docket.
Yes, that's the one. In that suit, Justice Abdulmalik essentially condemned and, totally dismantled the entire Congress architecture built by the David Mark-led faction of the African Democratic Congress, the ADC.
She didn't just dismantle it, though. She issued restraining orders against the Independent National Electoral Commission, INEC.
Right.
That means INEC is legally barred from recognizing any Congress, or any candidate for that matter, produced by the Mark faction, and with the electoral clock ticking down to zero, this creates an absolute institutional blockade.
So the fundamental tension we are unpacking today is really this. Does the federal high court's strict enforcement of internal party rules represent a necessary vital victory for constitutional order and democratic integrity? Or
does it constitute a rigid judicial overreach that paralyzes a major opposition coalition just ahead of critical electoral deadlines? Because that is exactly what I'll be arguing.
Well, I will be arguing that Justice Abdulmalik's ruling is an indispensable defense of the rule of law. It explicitly enforces Section 223 of the 1999 Constitution, which is designed to protect internal party democracy from arbitrary, unconstitutional takeovers by unelected caretaker committees.
And I will argue that applying rigid legal formalism at this precise moment completely ignores functional political reality. By stepping in with heavy-handed restraining orders so close to INEC deadlines, the judiciary isn't just refereeing a dispute. It is creating an institutional paralysis that destroys the electoral viability of the opposition. It effectively decides the 2027 elections before a single ballot is cast.
Let's actually look at the mechanism of what happened here, because my position is built on basic constitutional hygiene. Political parties are not private clubs where whoever shouts the loudest gets to make the rules.
True, they are statutory bodies.
Exactly, governed by the Nigerian Constitution. We have a group of plaintiffs in this suit: Don Norman Obinna, Johnny Tove Derrick, Oba Siehigidor, and several others. These aren't just random aggrieved members complaining from the sidelines.
No, they represent the duly elected state chairpersons and executive committees across the country.
Right. They are the actual grassroots engine of the ADC.
You mean the Nafiu Balagombe aligned faction?
Yes, exactly. And they identified a fatal structural flaw in how the David Mark-led faction was operating. The Mark faction had set up a Caretaker National Working Committee, an NWC. By definition, a caretaker committee is a temporary, unelected body meant to merely oversee a transition.
A placeholder, essentially.
Right. But this caretaker NWC attempted to bypass the actually elected state executives to appoint its own committee to conduct state congresses. Neither the ADC's own constitution nor the Nigerian constitution empowers an interim body to dissolve or bypass elected lower branches.
Okay, but
by affirming the 4-year tenures of the existing state working committees, Justice Abdulmalik is simply enforcing Section 223, which explicitly mandates internal democracy. If we let an unelected caretaker body usurp the grassroots structures, we don't have a democracy anymore. We have an oligarchy masquerading as a political party.
That sounds perfectly hygienic in a law school textbook. It really does. But you have to look at how that strict adherence to theory actually functions in the real world right now.
The real world is governed by laws.
Yes, but the court hasn't just clarified a rule here. It has effectively frozen a major political vehicle on a busy highway. You cannot discuss this ruling without looking at the unforgiving calendar enforced by INEC. If you are a political party in Nigeria, INEC's timetable is your heartbeat.
The deadlines are strict.
The absolute deadline to submit the party membership register is May 10. The absolute deadline to complete your party primaries is May 30.
Strict deadlines, to be sure, but deadlines apply to everyone equally.
They are existential deadlines. Because INEC is currently restrained by the court from recognizing the Mark faction's congresses, that faction is locked out of the administrative portal. Without INEC-recognized state congresses, you cannot physically hold valid primaries.
Which is the consequence of not following the rules.
Without primaries, you have no candidates on the ballot, period. By applying this sweeping legal blockade right now, the court leaves absolutely no administrative pathway forward for the coalition built around the Mark faction. We are talking about the entire opposition architecture here.
But is that really the court's fault?
When a judicial order dictates that a mega-coalition cannot participate in the democratic process because of an internal dispute over who appoints a Congress committee, the judiciary is no longer a neutral arbiter. It becomes the executioner of political campaigns.
Okay, but wait. Is that the court's fault, or is it the fault of the massive political figures for hitching their wagon to a legally defective caretaker committee? You can't blame the judge for pointing out that the car you just bought doesn't have an engine.
I wouldn't say it didn't have an engine.
The judiciary isn't executing a campaign. It is penalizing a faction for fundamentally violating the rules of the sport, which leads us to the core of this dispute, the issue of justiciability and jurisdiction. The Mark faction's primary defense was essentially, stay out of our yard. They argued that courts shouldn't interfere in the internal affairs of political parties.
Which is a deeply established precedent in Nigerian jurisprudence. Historically, courts have recognized that if they interfere in every single ward-level squabble, they become the HR department for every political organization in the country.
That is generally true for internal policy, yes. But Justice Abdulmalik rightfully dismissed those preliminary objections because of Section 251 of the Constitution.
Ah, Section 251.
Right, which gives the federal high court exclusive jurisdiction over matters pertaining to the administration, management, and control of the federal government or any of its agencies. INEC is a federal executive body. When a rogue faction tries to force INEC to monitor and legally recognize an unconstitutional Congress, it ceases to be an internal party matter. It becomes a federal legal issue.
I come at it from a different way, actually.
Let me just finish this thought. Think of the caretaker committee like a temporary house sitter. If the house sitter decides to forge the deed and sell the property without the owner's consent, the true owners, in this case, the elected state executives, have to go to court. You cannot tell those elected executives that they have no legal recourse to stop the house sitter from transferring the title simply because it's a family matter.
Right, but that assumes the house was in perfect functioning order before the sitter arrived. Political parties in the middle of a factional crisis are not orderly houses. They are burning buildings.
That doesn't mean you let it burn.
The Mark faction's jurisdictional argument wasn't just a blanket demand for judicial immunity. It was grounded in the principle that a party's internal dispute resolution mechanisms must be exhausted before you go running to the federal high court. By jumping straight into the federal high court, the plaintiffs bypass the entire concept of allowing a political institution to heal itself.
But the judge noted that trying to determine if those internal mechanisms were exhausted at the preliminary objection stage would essentially mean deciding the substantive questions of the case prematurely.
And by refusing to weigh that, she jumped straight into issuing substantive, sweeping restraining orders. This is exactly the danger. When the court bypasses the requirement for a party to resolve things internally, it institutionalizes chaos.
I completely disagree that the court institutionalized chaos here.
Yes, Section 251 gives the court jurisdiction over INEC. But using INEC's involvement as a backdoor to dictate which specific internal party faction has the right to appoint a Congress committee is a massive expansion of judicial power.
How is enforcing the Constitution an expansion?
It sends a message to every single aggrieved party member in Nigeria. Don't bother sitting down with your party's conflict resolution committee. Just file an originating summons in Abuja, claim INEC is involved, and get an injunction. That paralyzes the political system.
I see why you think that, but let me give you a different perspective here. Let's look at the actual behavioral timeline of the factions, because that context explains exactly why the court had to act with such heavy-handed injunctions. It wasn't a rush to judgment. It was a response to blatant defiance.
The timeline is what's causing the panic in the first place.
The timeline is what the Mark faction abused. Go back to March 12th. the Court of Appeal dismissed an appeal by the Mark faction and explicitly directed all parties to maintain the status quo antebellum.
Yes, the freeze order.
For those unfamiliar, that is a direct judicial order to freeze everything exactly as it was before this legal fight even started. You do not make any moves.
In theory.
Not in theory, in law. What did the Mark faction do? While waiting for the Supreme Court to hear their further appeal, they completely ignored the appellate court's freeze order. On April 14th, they proceeded to hold a massive national convention.
Because the election doesn't pause for litigation.
They passed sweeping constitutional amendments. They even went so far as to expel figures from the opposing faction, like Nafiu Bala Gombe and Leke Abajid.
They were trying to solidify a political coalition in the face of a deadline.
They were actively creating a parallel party structure in direct defiance of a standing court order. They were daring the courts to stop them. The Federal High Court didn't just suddenly decide to micromanage the ADC. It had to drop the gavel because its authority and the authority of the appellate courts was being openly mocked.
Mocked is a strong word. You simply cannot march into a courtroom and demand judicial restraint when you are actively, publicly ignoring the judiciary's existing orders.
You are treating this as a simple, sterile equation of order and disobedience. But political time does not stop for judicial delays, and you are ignoring the actual underlying strategy here, the weaponization of time.
The weaponization of time. What do you mean by that? In election law, an injunction delayed is an election denied. The Mark faction wasn't mocking the court for the fun of it. They were suffocating under the weight of an electoral timetable that waits for no judge.
That's the reality of litigation.
Lower court orders are routinely weaponized in Nigeria to run out the clock on opponents. The Nafi Bala Gombe faction didn't need to secure a democratic mandate. They just needed to secure enough injunctions to hold the Mark faction down until the INEC calendar expired.
That implies the Gombe faction is just being obstructionist rather than defending their legally mandated 4-year tenures.
Look at the sheer desperation in the legal filings, though. On April 28, the Mark faction's counsel, a senior advocate of Nigeria, Shaibu A. Arua, wrote a letter directly begging the Chief Justice of Nigeria for a Supreme Court judgment within 3 days.
I saw that. Highly unusual.
Extremely. Assan does not write a letter pleading for a 3-day turnaround unless the structural survival of his client is at 0 hour. The lower courts issue a status quo order, which freezes the party. Then the appellate system takes its time, moving at the pace of normal litigation.
Which is how the justice system works.
But INEC doesn't care about the pace of litigation. May 10 is May 10. May 30 is May 30. If the courts hold you in a freeze until June, you have missed the election. The judiciary isn't just refereeing. By holding the clock, they become the executioner.
I'm not convinced by that line of reasoning because, frankly, the electoral ambitions of individuals, even political heavyweights, do not grant them immunity from constitutional law. You are essentially arguing that because the clock is ticking, we should look the other way when an interim committee illegally usurps power from elected state executives.
No, I'm saying you have to balance the harm.
But let's actually look at what the Abdulmalik judgment does. It does not destroy the ADC. It clarifies its legal structure.
It clarifies the structure by handing the keys to a faction that doesn't have the political mass to actually drive the vehicle.
It hands the structural architecture back to the duly elected state executive committees. The court explicitly affirmed that the 4-year tenures of the state working committees aligned with the Nafiu Bala Gombe faction remain valid and subsistent.
Which solves the legal issue, maybe.
This means there is a legitimate, entirely legal path forward for the mega coalition. The court didn't close the door to the ADC participating in 2027. It just pointed to the legally compliant door.
It's not that simple.
If the Nafiu Bala Gombe aligned state executives act quickly, they have the formal judicial recognition needed to conduct valid congresses. They can submit a register to INEC by May 10. They can hold primaries by May 30. The failure of the Mark faction to recognize this legal reality and cooperate with the legal state executives is what is jeopardizing the coalition, not the judge's enforcement of the law.
That's a compelling argument, but have you considered the actual political sociology of this coalition? Because what you are suggesting is politically impossible.
Politically difficult? Maybe, not impossible.
No, impossible. The law might say the Gombe faction has the keys to the car, but the Mark faction has all the fuel, all the passengers, and the actual engine. Let's look at the centrifugal forces already tearing this party apart. On April 28, we saw reports of Salisu Marafa, a prominent ADC member in Sokoto, defecting to the New Democratic Congress, the NDC.
Defections happen in every election cycle. One politician moving to the NDC doesn't mean the party is collapsing.
Marafa leaving for the NDC isn't just a routine defection. It's a margin call. When investors see a company's assets completely frozen by litigation, they don't wait for the court case to resolve. They pull their capital immediately to avoid bankruptcy.
Politicians look out for themselves, sure.
Politicians are pulling their electoral capital out of the ADC before the May 30 deadline renders them obsolete. Think about the massive figures involved in the Ibadan Declaration. Atiku, Obi, Kwankwaso, Amachi.
Heavyweights, yes.
These are titanic political structures that attended the ADC's April 14 convention, intending to use it as their mega coalition vehicle. Do you honestly believe the massive multi-state political machines of Peter Obi or Atiku Abubakar are going to suddenly submit themselves to the relatively small, localized Gombe faction state executives in a matter of days just to meet an INEC deadline?
If they want their names on the ballot, they have to follow the legal structure. It's that simple.
But the friction is too high. They tied their presidential ambitions to the ADC, and Justice Abdulmalik's ruling, paired with the Supreme Court's current silence, has left them with a legally unusable vehicle. The mega coalition is going to scatter to other smaller parties or fracture completely, simply because the judicial obstacles are too high to navigate in a 2-week window.
It may be politically difficult, I concede that. But the alternative you are proposing is legally impossible. INEC cannot, by law, recognize a primary that stems from an invalid Congress.
Even if that Congress represents the actual political mass of the party?
Justice Abdulmalik was unambiguous. Neither the Nigerian Constitution nor the ADC's own constitution empowers a caretaker committee to bypass state executives. How can you expect INEC, an institution bound by strict statutory guidelines, to monitor and validate a primary process built on a completely void foundation?
But the foundation...
If the foundation of the skyscraper is poured on land you don't own, the city inspector has to shut down the site, no matter how many rich tenants have already bought penthouse suites.
But look at what happens when the foundation is condemned this late in the build. If the Supreme Court ultimately rules, let's say in late June, that the federal high court actually didn't have jurisdiction to hear this originating suit in the first place, then all of these restraining orders issued by Justice Abdulmalik will be vacated.
That is true. If the Supreme Court rules against the federal high court's jurisdiction, the orders fall.
But by June, it will be too late. The May 30 primary deadline will have long passed, the mega coalition will be dead, the judiciary will have effectively dismantled the opposition based on a jurisdictional error that was corrected a month too late.
That's a hypothetical outcome, though.
This is the exact danger of the weaponization of time. Every single day of delay is a day the lower court's restraining orders operate to functionally exclude the opposition from the democratic process. We are sacrificing the macro-democratic process of a national multi-party election on the altar of a micro-democratic dispute over an internal party memo.
I completely reject the framing that enforcing the Constitution is a sacrifice. Enforcing the rule of law is the absolute prerequisite for a functioning democracy. Let's synthesize exactly where we stand on this, because the implications extend far beyond just the ADC.
They do.
From my perspective, Justice Abdulmalik's judgment and the specific restraining orders against David Mark, Patricia Akwashiki, Bolaji Abdullahi, Ralph Aregbesola, and Osirheimen Asambar are vital, necessary interventions.
I mean, they are definitely interventions.
They ensure that only legally constituted, duly elected bodies govern political parties in Nigeria. It sends an unequivocal message. You cannot use interim committees to bulldoze constitutional structures, and you absolutely cannot ignore appellate court status quo orders without facing severe legal consequences.
And from my perspective, this entire saga represents a critical systemic failure of how our institutions interact. This accumulation of injunctions, the resulting INEC derecognitions, and the strict adherence to legal formalisms are systematically dismantling opposition structures right before a major election.
We certainly see the consequences differently.
When a political party's survival on the ballot is dictated not by the voters, but by whether a senior advocate can successfully beg the Supreme Court to rule in 3 days to beat an administrative deadline, the judiciary has overreached. It has replaced the political process with a judicial obstacle course.
Well, despite that massive divide in our perspectives, there is a clear area of convergence. We both agree that the ADC's survival as a unified entity, and perhaps the survival of the entire 2027 mega coalition, is currently hanging by a very thin thread.
A microscopic threat, yeah.
And that thread is tied directly to the Supreme Court's pending decision on jurisdiction.
Precisely. The Supreme Court holds the ultimate key here. If they find the federal high court lacked jurisdiction from the start, this entire blockade dissolves, though perhaps too late to save the timeline.
Right.
But if they affirm the jurisdiction, the Mark faction is definitively out of legal options. We simply disagree on whether Justice Abdulmalik's ruling in the interim was a necessary constitutional cure or a fatal blow to the party's viability.
Which really highlights just how incredibly complex the intersection of constitutional law and political reality truly is. You can have a legally sound ruling that creates a massive political crisis, and you can have a political necessity that violates the core tenets of the Constitution.
It is the ultimate friction point of a developing democracy. As those unforgiving INEC deadlines of May 10 and May 30 approach, watching how these titanic political figures either adapt to this new judicial architecture or abandon it entirely will reveal a lot about the resilience of Nigerian democratic institutions.
It certainly will. The next few weeks will test whether the system can actually handle the weight of these disputes without collapsing the electoral timeline entirely. Thank you for joining us on The Debate.